Might use this as a shameless plug for the Historical Society, oldest journal in Australian history, for Australian history since 1901. Always looking for submissions. So consider that for people here. Is this going to work? Perfect. Great. The context here, my mum's side is from Bingra, right? The last name's Camden. There's a fair few Camdens there. My grandma is one of 10, all from Bingra, all still there. I didn't grow up in Bingra, but I've been there so many times, right? Remember going to Myall Creek a fair bit. Every time we drive by, there'd be sort of discussions about it. My mum's dad is Gamilaroi. There was always discussions there. That's my mum's side. On my dad's side, and here we have the competition between New England and Bathurst. My great-great-grandfather was Major Morisset, who was the commandant of Bathurst who crushed the Wiradjuri. He got very rich, and the family didn't have to work for about 4 generations because he took 43 Wiradjuri heads, sold them, and bought land with that, right? So we have there a pretty distinct mum and dad side. I was talking to Cameron about this a couple of years ago, and we were talking about just that schism that occurs right between, because we're lawyers, we work together in the military, this schism that occurred between the legal frameworks that applied during the frontier wars. And I got very, very interested in it. Very interested in if both sides were playing by their rules, how do we actually talk about war crimes? How do we talk about breaches of the laws of war from an Indigenous and a non-Indigenous perspective? So that was about 5 years ago. Since then, have done 5 years of research, both doctrinally and also in community and on country, trying to identify what were the laws of war in Australia from an Indigenous perspective, right? So that is the big background here. The connection to Myall Creek is not one that is immediate. I'm not saying these are Gamilaroi laws of war. It's not a case study of Myall Creek, but it is a wider, bigger discussion about the legal frameworks that were in play. Now, I do it for sort of 4 reasons. I wear a couple of hats. One hat is as a major in the Army. I've been appointed as the first Army Fellow at the Australian War Memorial. And what we're doing there is creating an exhibition over the next 3 years on the Frontier Wars, right? Now, the Frontier Wars, big debate going on about how it fits in with the statutory framework of the Australian War Memorial. The Australian War Memorial is only allowed to look from 1901 onwards because it's the Australian War Memorial from Federation. So the way we're getting around that is that we're looking at Australian Army units since 1901, and specifically the Arnhem Squadron up in Arnhem Land is a Yolngu regiment. I'll be talking a little bit about that today. So outlining the history, canvassing the lessons that we can learn, acknowledging that the shared connection that we have in the Army is one of warriors, both sides fighting for country, and demonstrating how this can be applied contemporarily within modern Australia. Cool. Questions, I think, throughout, if that's all right, rather than it, because occupational hazard, I'd like to talk, so I'm probably going to go pretty flush on the 30 minutes. Cool. Obviously, me on the left with one of the 2 kids. On the right, though, this is 2015 at Gallipoli. What we did there was, that's not me. This is a lieutenant colonel. I do not have that many medals. But to recognise that the First Nations soldiers who had died at Gallipoli, ceremony was conducted there to not to exhume bones and bring them back, but it was to bring peace, bring a sense of peace at Gallipoli, right? Now that's pretty powerful, and I put this up there because it's very easy to forget, right, that this is something that we're trying to grow and evolve and adapt to the times, recognizing what was wrong, Not saying that the army was involved in Myall Creek, but recognising what was wrong and taking proactive steps. Sorry about my voice. Cool. This guy's called Donald Thompson, anthropologist. Some people may have heard of him. In the 1930s, he went up to Arnhem Land. He worked with the Yolngu. He was initiated and adopted by an elder called Ray Waller. And when World War II kicked off, he made an argument down in Melbourne that a regiment should be raised in Arnhem Land to repel the Japanese. And he suggested in a very similar way that had been happening across Empire that local troops should be galvanized and used as a special reconnaissance unit. Now, the image there on the bottom left of the, I'm going to say dragon, but it's not actually a dragon. It's got a very specific mythological reference. It's a werven. That is the symbol of Special Operations Command. So 2 Commando, SAS, whatever. The director of Special Operations in 1942 was a fellow called Lieutenant Colonel Scott. And he came to the conclusion that if he was Yolngu, he would go with the Japanese. He would support the Japanese. Much closer connections with the Macassan traders, with everyone, than to white fellas, right? So he said to Thompson, you're now a squadron leader, which is a major equivalent. Go up there and create a unit. So he did that. A lot of people would have heard of Stanner, William Stanner and the Rough Riders, and he had his own sort of company. They were out west. Thompson was actually Stanner's commanding boss, right? And they have a big blue at one stage about who is the commander. Stanner was, but he kind of got a little bit Thompson was, but Stanner kind of wrote him out of the history books. Thank you. Right. Now, Stanner got permission to take these photos. And these photos, there's 140 photos, and they've been given to us at the Australian War Memorial. A Makarrata was performed in 1942. People probably have heard of the concept of Makarrata, right? It's a sort of a logical voice treaty, truth-telling. Makarrata was often held. Makarrata is a Yolngu term. And Ray Waller, who was one of the soldiers wearing dog tags, enlisted in the army, went around Arnhem Land and said the best way that we can unite is we will conduct a Makarrata. And at the end of that, we will all join the army and we will repel the Japanese. What we have here is just some of the photos that I think are particularly brilliant. But the unique part about this Makarrata was that it wasn't just Yolngu. These are Solomon Islander soldiers who travelled with Thompson. Women were involved. Torres Strait Islander soldiers were involved. Caucasian officers were involved. It is a very, very inclusive ceremony, central to the Yolngu concept of the laws of war, and something that at the end actually created what is now Arnhem Squadron. Arnhem Squadron goes back to this moment. It's pretty unique in Australian history. So that's the Norforce symbol down the bottom right. That is where Arnhem Squadron falls into. We've also, people who've read Henry Reynolds would have heard about his big thing about the Larakich. These are the Yolngu funeral pyres. This here is in the National Gallery. Reynolds has a big issue with that it's considered a piece of art as opposed to a war memorial. Well, very happy to say that at the Australian War Memorial, we've now commissioned 15 of these to commemorate the Makarrata. So that'll be being advertised. Sorry, that will be done and acquired in the next 3 years. What we have there on the left is actually the Larakich being made in 1942, right? And so Thompson took those photos. Right. So this all comes to say that some of this research that we've been doing, I've published in the big center book there. And that research looks at the idea of laws of war across Australia. It's something that's getting bigger and bigger as we go through. In doing it the right way, though, you can't rush it, right? You got to be on country. You got to be talking to communities. So Arnhem, the Yolngu elders recently have all voted to have what they're calling a law warrior. They are funding for him to come down to Adelaide, and he'll be doing his PhD under me at Adelaide, looking at Yolngu laws of war and how we can apply it in the 21st century. It's a very slow process, and we're trying to replicate it across the country. Now, I put this up here because I think as we go forward and I start talking about the lessons, we sort of need to talk about the limitations, because I'm not saying by any means that this is a set process. Very big difference between transcribing and translating, right? You conduct an interview, it's transcribed. There's a lot of language that is missed in that transcription. Even more language and nuance that is missed when you translate. So the laws of war that I'm about to articulate are ones that I have translated. The transcriptions are found in other research, which I'm very happy to send around. And then the originals are found in IATSIS, where we're putting them for storage. The big so what here. So Jean Pitet was the head lawyer for the International Committee of the Red Cross in the 60s. People probably have heard about the laws of war, right? People have probably heard about LOAC, maybe, laws of armed conflict. Most people talk about IHL, or international humanitarian law. We may have heard that idea. Humanitarian law is a buzzword that Jean Pitet came up with to humanize what is actually the laws of armed conflict. Very forward thinking. And he had this idea that if you compared every culture in the world and you distilled it to its basic principles and how it regulated warfare, you would find commonalities, right? He said that in the 60s. What I'm trying to do in that series that I've edited, so you see there's 3 books up there. So there's 3 out, there's another 4 to come. Each chapter looks at a different culture. And we're trying to get across and try to figure out, please. No, please. Principles as it relates to war.
Did he talk about?
So he's talking about, it's a good question. So when he talks about humanitarian ideals, he's talking about it through a very small lens of his position at the Red Cross. And the Red Cross only deals with the laws of war. So the International Committee of the Red Cross is created by the Geneva Conventions. So this book, it's explicit. So he talks about the dimensions of humanitarian law. So what he's saying there is the laws of war. Yeah. So even in recognizing that, we're still stuck within a legal framework, right, of the Geneva Conventions. I'm not going to ask Cameron this because Cameron probably has read the Geneva Conventions. If you're captured as a prisoner, how much do you get paid a day? Anyone? 12 Swiss francs as an officer, 6 Swiss francs as a private. Do you reckon if you're doing university, you're allowed to continue in a prisoner of war camp? Yeah. If you can be given internet, you got to get internet, right? These things are incredibly, incredibly restrictive, outdated, some would say. They do not reflect the modern battle space. What they do reflect is 15th century European norms that if you're captured, you are a knight. The idea of being on parole is a concept from medieval chivalry, that you could go and get your money and come back. These systems are designed around the rules of chivalry that have evolved. They have gotten bigger, but they are very European. International law is also incredibly colonial. I don't win any points for saying that. It's not an original observation. But this here is quite an interesting, I'm going to move this so you can see the date Quite an interesting image that I think captures international law. The East giving its riches to Britannia in its rightful place, being given the world, right? International law developed to reflect that. And so what about non-European laws of war, right? Non-European laws of war are something that is increasingly being looked at. Here we have Somalia and here we have the Pacific. But it's not something we've ever looked at within Australia because there are a lot of different nations here and there's a lot of different laws of war. So Freycinet, as he travelled around, was shocked that you could go from country to country and not be able to speak the same language. And his end proposition was that was because the borders had been so static and controlled by military force for so long that there hadn't been much of a movement of people, right? Imagine that within, accents change within Yorkshire, but people aren't speaking different languages in Yorkshire. Yeah. Here, completely different language systems because completely different countries. And we're pretty clear that this happened around the same time, around 10,000 years ago, when the water was coming up and people were moving inland and desert was happening and people were moving out. There is a big movement of people. There is a lot of conflict going on. And yet, after 8,000 years, artwork goes back to focusing on ceremony. So something happened. Systems evolved, systems changed. Critical legal theory would say that the law is not perfect. If it was, we'd all have the same law. Law changes by social interaction. Law evolves to meet social expectations. And the laws of war are no different. This is a photo from Mickey of Ulladulla. Unfortunately, we don't actually know his name. That's just what he was called. It's the only photo we have drawn by an Aboriginal man of intra-Indigenous warfare. Yep. And so what was happening at these times? Not big wars of conquest, but the laws of war from an Indigenous perspective was one of balance. If we think about the European model, it's about winning. It's about putting your flag in someone else's capital city. It's about taking their stuff. Here, a completely different legal system evolved. One of balance, one of de-escalating situations. I think one of the most, Bo Spearham, who's coming later, he and I've yarned about this a fair bit. Really interesting that in his country, if we were having a fight and I cut him, at the end of the fight, he would cut me back in the same spot. What an absolutely brilliant way to stop. I don't want to get my hamstring cut. I'm not going to cut his. Now, of course, these are 5 different countries, right? 5 different concepts of laws of war. This is in one country. This is Waralpiri. We can see it's actually quite a very nuanced concept, right? Different terms here to reflect different breaches of the law that could occur and the consequences. So across Australia, the research that we've been doing, these are the 8 laws of war that we've been able to identify that have applied across all countries, all communities. I keep trying to narrow this down. So in the scientific method, I want to be wrong. Test it, see if it doesn't work. These are the 8 that do work. And to some extent, they actually do marry up with European laws of war. You don't attack someone who's not a combatant, doesn't have the same standing. Within customary international humanitarian law, Rule 1, concept of distinction. Unnecessary wounding, make sure that the enemy is not caught unaware. Help those that are wounded. And it's pretty important, right? Because early colonial observers couldn't get their head around the system here. Everyone's having a big fight, and at the end of the fight, people are friends again. That doesn't work from a European model. You fight to win. You don't care about how they feel at the end. A system that evolved here was what we call a spectrum of competition. You are concurrently cooperating. You may be competing over some things, and sometimes you have conflict, but it's not this idea of war and peace. Binary concepts. You're either at peace or you're at war. Very European. very hard to reconcile. And yet, and I know at the time, and yet we kind of are, right? So Arnhem Squadron. This is a photo I took a couple of weeks ago up in Arnhem Land. The soldiers up there still continue to work within their legal framework and yet work within a military construct as well. The Arnhem Squadron is quite unique in a very similar way to the Torres Strait Regiment. People are recruited from country. When you're doing planning, it's not white officer going around saying, all right, we're going to go through here. You turn around and you say, all right, we're going to work here at Trial Bay or Milingimbi or Ramingining. Who's from that country? And a private might put his hand up and say, I'm from Ramingining. Great, you're leading the patrol. It's your country, it's your rules, we'll follow you. It's taken a long time, it's taken 80 years, but it's something that evolved by Thompson being able to actually utilize the different legal frameworks as he saw it. I think, as we were talking about this morning, Cameron and I, as we move forward, this is kind of a model that can be used, right? If you take the time to learn the legal frameworks, it's something that you can incorporate. I don't think that they are necessarily unable to exist together. Like a lot of people say, if we go back from a law of war perspective, there is a lot of crossover. As we move forward, there's a lot of crossover. We just got to stop. We've got to yarn. We've got to figure it out. Thanks. Oh, 2 minutes over.
Excellent.
So just wondering if anyone has any questions that they would like to ask.
Thank you very much. That was really fascinating, Sam. I've got 2 questions for you. You talk a lot about moving forward. First question is, what is your feeling about the capacity for the European legal system that we are operating under to incorporate this historical other form of law and wisdom rather than work kind of perhaps in tandem or in opposition? And the second question I have is, given my understanding of our legal system, which is not from an expert's perspective, it seems to me that law is very often determined in the present based on precedent, and therefore our capacity to amend our frameworks for future scenarios or an evolving scenario is hamstrung by the fact that we focus on precedent. Can you comment on the 2 of those, if you remember? Sorry.
So first one, we're never going to have a big system break, right? The court is very clear that it can't question its own foundation, and the High Court can't. It can't turn around and say, but it can say, no, it wasn't terra nullius, but they can't say it was anything else. Because the court isn't all powerful. The court is created by the Constitution, and the Constitution is based upon certain frameworks, and the court can't go outside those frameworks. Just like the court can't create law through statute because the Constitution says it can't. It's very much controlled by itself. And there's this concept of justability. So if something is justiciable or not, it means, can the court hear it? So there are certain no-go zones in the Constitution that the court can't look at, and they say this is a non-justiciable matter. One of those is the foundation of this country, the legal frameworks that applied. They can say terra nullius clearly wasn't met, full stop. But that's why they don't go forward and say it was therefore this. That's for Parliament. And Parliament did do that in the 80s. And effectively this thing about, it was called prescription, that, sorry, not the 80s, mid-90s, yeah. Prescription was given as the legal foundation, which is, we've been here, so colonizers have been here too long to go back and change it. We're stuck with the system we got. Now, that's that. Very recent case, about 3 years ago, called Love in the Commonwealth. It's about individuals who were going to be deported because they had broken migration law, gone to jail for more than 12 months. 2 individuals turned around and said, you can't actually deport me. I am Indigenous, even though I don't have an Australian passport. One was born in New Zealand, one was born in PNG. I do not have an Australian passport, but I'm not an alien for the purposes of the Constitution. And the court agreed. You can't deport Indigenous Australians, even if they're not holding an Australian passport. Now that to me, and we've talked about this a fair bit, that to me is a much more landmark moment than Mabo in some respects. And that's a big call to make, and I realize that's a big call. But it's actually recognizing that within, even if it's not in the Constitution, that no matter where you are in the world, if you're Aboriginal, you have a right to live in Australia, even if you don't have a passport. Why? Because there is some little vein of law that exists that recognizes a dual stream. It's not just white law. There is some underlying blackfellow law here. It's not in the Constitution. It's never said, but the court is very clear with this new case that there has to be some concept of Indigenous law that exists and is reconcilable with the Constitution. Otherwise, if whitefellow law won, doesn't matter if you're Aboriginal, if you don't have an Australian passport, the Constitution is very clear. You can't stay here if you break the law. Goodbye. So it's Section 501 of the Migration Act.
Okay, 1, 2, 3.
Howdy. Howdy, my name's Peter Stevenson. I'm third cousin, fourth removed from John Henry Fleming. So bring it back to Myall Creek. I went to the White Noise of Settler Law with Tim Goodwin. It was a webinar at Melbourne Uni on behalf of our local advocacy group down in Melbourne. So I just wondered with the Gamilaroi law versus the Australian law, with him escaping justice, like he came out after only 2 years and lived a model life, supposedly, whether there's any, how the Gamilaroi law works with that, and how the, or any of the other First Peoples law systems, and also whitefellas law for justice after the event.
Yeah, I mean, I know here in Armidale, they have the Koori courts. Is that correct? Circle sentencing. I think we're slowly moving towards this idea in terms of how do you reconcile it? And it goes back to the earlier question about how do you reconcile legal systems? It's pretty hard, especially if whitefellow law says that you can't question your origin. So there can't be separate courts. The Constitution is very clear on that. There can't be a military court. It got shut down in mid-2000s because it broke the Constitution. They're very, very clear. Case for that is Lana Morrison. Thank you. But you can have sentencing. They can help with sentencing. NARJA, up in the Northern Territory, is a big part of sentencing. I think that's how it gets reconciled, is it's a sentencing consideration. Yep.
Okay, so we'll just have these last 2 questions, and then if you've got others, I'm sure after the proceedings, you'll be happy to answer.
Of course.
Hi, thank you very much for that speech. It's really important to talk about, war in the context of contested space. So my name's Myall. I'm a Dharug and Ngurrabal woman, and I wanted to ask you about Jack Congo Myall and that case in 1836 where he went to court and he said that the laws of his native laws were here for millennium. So, and that it was thrown out of court.
Yep. So it's non-justiciable. That's the short answer. Non-justiciable, Myall. There's a bunch of cases, right? There's some really interesting work out there that looks at this sort of the progressive questions that came up. I think what people may not be aware of is in Victoria, that argument was run many, many times by many, many lawyers. and universally was shut down. Sorry, not universally. It was shut down 99% of the time, except once in Victoria, where the court turned around and said, definitely do not have the jurisdiction here. There's no possible way we've got this jurisdiction. And that was actually overturned by the governor in Sydney saying you can't break the system. So the short answer is it's a non-justiciable matter because courts can't question their own existence. That's not to say academics can, of course we can, it's our job. Fully agree. 100%. I mean, I wrote, I'm not sure how we sent it around. We've got a paper coming out in the next month or two that looks at that exact question, that effectively through whitefellow law shows just how like every time you hit the marker, it changed. It's just politics, big politics. Yeah, I agree.
This kind of goes back to a little bit what Catherine was asking you about. And I just want to, because I don't know that much about law. I once did some legal research for Charles Sturt Uni, actually, on Indigenous hunting and gathering rights a long time ago. But my understanding about like customary law was that it was analogous to like common law, and common law can be like unwritten law. It sort of, I kind of see it almost like a class sort of thing.
Yeah, it is the common law.
England, the common law is
Dane law
the way
still
of
applies in
people,
York.
the ordinary people asserting their rights, and the written law was often about keeping people in that place.
That's an interesting
right?
analogy. Yeah, I mean, no, and
I
I
come
think
from the north of England, so
which part?
Blackpool originally.
There you go. All right. My wife's from Yorkshire. And I only say that because I know York law still contains Dane law from the Vikings.
Yeah.
So the common law there still incorporates Dane law to an extent because it hasn't been overruled. Common law is a really interesting creature. It's something that evolves from customs practice. And I will think about your point about statutory law. Yeah, and I note the hovering, so don't worry. I think on your point that William Blackstone, English jurist, wrote about what is conquest, and that is what the courts here in Australia refer to, Blackstone's role. Terra nullius, conquest, treaty. Only 3 ways that Blackstone says you can take over somewhere, right? So conquest isn't what we think it is. It's not necessarily walking in and winning. Conquest is the act of putting your laws on someone, right? Statutory laws, when you don't have a right to. And doing it long enough is what Blackstone would define conquest as. Done. Thank you.